I must say there are lot many ups and downs as far as this personal guarantors insolvencies are concerned. And I still remember the controversy was still not over after 15th November 2019 circular, wherein the personal for as far as this code is concerned, code part 3 of this code, chapter 3, which has been notified for a personal guarantor, and thereafter the Lalit Kumar judgment, and again a recent judgment wherein the Supreme Court has cleaned the air as far as the constitutional validity of section 94, 95 and up to section 100 is concerned. As far as the personal guarantee is concerned, what I can anticipate in the time to come is, now resolution plan will be drafted, will be prepared in a manner so that the protection can be extended to the personal guarantor of the corporate debtor, so that suppose if that resolution plan gets approval of the committee of creditor and subsequently by the adjudicating authority, at least the personal guarantor can safeguard their interest. Otherwise, what is happening these days is, the moment CIRP gets over, or even though when CIRP is pending, the banks and the financial institution, more particularly secured creditors, are moving an application under section 95 so that they can protect their interest as a whole in spite of accepting the haircut in the resolution plan. So one thing what I feel is there will be a changes in the way, the manner of drafting of the resolution plan, that is in the time to come. Secondly, what I feel is there will be change in the manner in which the corporate or the personal guarantees are being extended nowadays. So the directors are they are very casual in approach as far as the extending the guarantees are concerned, or executing the guarantee deeds are concerned. So there will be a change in that pattern in which the guarantees have been extended, or the guarantees documents are have been executed up till now. So as far as this part 3 is concerned, considering the time frame which is available up to 5 o'clock, the way we are going to extend the things, we will be taking care of how this controversy has been lastly ended by the Supreme Court. Thereafter, one NCLAT judgment in the matter of Ujas Energy, that is what we are going to take care of. And after completion of this NCLT or Supreme Court judgment, we will be taking care of part 3 of this particular code. We will be taking care of all these sections from section 94 onwards up to chapter number 3. And we will be taking care of the rules. So as far as this entire discussion is concerned, we will be taking care of from where the controversy has begun, how the controversy has begun, and what exactly the controversy all about. So yes, schedule as far as part 3 is concerned, or rules pertaining to the insolvency resolution of the personal guarantors are concerned, that is right now not so vital before understanding on what grounds the challenges have been made before the Supreme Court in the Lalit Kumar judgment and the recent judgment of the Supreme Court, which was decided upon on 9th of this November 2023. I'm just sharing a write-up, a formal write-up, which is going to help us out to understand where the controversy has begun and where the controversy has been settled up till date. We will be covering all three aspects. One is with regards to Lalit Kumar, another is with regards to the recent Supreme Court judgment, and one NCLAT judgment with regards to Ujas Energy, which is upheld by the Supreme Court. I'm just sharing the screen before we proceed further. I just wanted to seek your confirmation if it is visible, and if I'm audible, then we can very well proceed with the discussions.
Yeah,
Yes,
it's
sir,
visible
it
and
is
you're
visible
audible.
and audible.
Thanks, Lord. Thanks. Now, this is the genesis of the IRP insolvency resolution process of the personal guarantor. Now, as far as the topic is concerned, yes, it is for the operationalization of part 3 of the code. Now, as far as part 3 of the code, fundamentally, part 3 is applicable to the individuals or the partnership firms or the sole proprietorship concern. But till date, as far as the applicability on the individuals or a proprietorship or a partnership firm is concerned, that is not notified. But we are right now only concerned for the operationalization of part 3 for the personal guarantor of the corporate debtor. Those personal guarantor, those who have given a guarantee, who are acting as a surety in the deed of guarantee on behalf of corporate debtor in favor of a secured creditor. Several provisions of the Indian Contract Act is going to be discussed during the ongoing discussion. We will be taking care of three major aspects. One is that amendment which was taken place on 15th of November. That is going to be one of the fundamental, what we call a foundation of the dispute. That was a notification which was on 15th November 2019, and that has resulted to a Supreme Court judgment. So matter was not ended up there. That was Lalit Kumar Jain versus Union of India, wherein that notification dated 15th of November 2019, it was challenged before the Supreme Court by the way of writ. And thereupon, the multiple writ petitions which was referred before the Supreme Court challenging the constitutional validity of Section 94 up till Section 100. And recently on 9th November 2023, the Supreme Court has again upheld the constitutional validity in the matter of Dilip B. Jivrajka versus Union of India. So that is going to be one more area of discussion we are going to take care of. And lastly, we will be dealing with recent NCLAT judgment. The matter went to NCLAT based on the order which was passed by the NCLT Indore bench in the matter of SVF Family Trust versus Ujas Energy Limited. And yes, this was decided upon by the NCLAT recently, which was again challenged before the Supreme Court, but Supreme Court has upheld the order which was passed by the NCLAT in this particular case. So we will be taking all three into consideration before we actually deal with part 3 of the code, section 94 onwards up to section 118, 119, that we are going to formally take care of. But before we moving into that part, let us see the controversy, the grounds of controversy, how the creditors have feel aggrieved or how the personal guarantors have feel aggrieved. That is something we need to take care of out of this 2 Supreme Court and 1 NCLAT judgment. So this is the genesis. I'm just rotating the screen in case if there are certain point of discussion or some deliberations are required, we are surely going to take care of. And I must say that rather than discussing the questions at the end, we will be discussing the relevant question at that relevant point of discussion that probably keep the things interactive. So prior to the introduction of the code, it is something which is settled and known to every participant that insolvency resolution of the individuals was governed by the Presidency Towns Insolvency Act and Provincial Insolvency Act, which got repealed by the virtue of 243 of the Insolvency Code. Many of the acts have been repealed, and these were two of the acts which got repealed by the virtue of section 243 of the Insolvency and Bankruptcy Code. The amendment, that is 2018 amendment, which was a seed of the controversy. Because of this amendment, there is an amendment to section 2 clause E of the code, which has made the provisions of the Insolvency Code applicable to the personal guarantor. So there were three specific categories which was emerged out of this amendment. I said this is an 2018 amendment which has led to an amendment in section 2 with regards to applicability of the code, and clause E of the code, that is section 2 clause E of the code, has made a provisions of the code applicable to the personal guarantor of the corporate debtor, which are majorly the company's board or the promoter or the KMPs. The unamended section 2, the unamended section 2, which made provisions of the code applicable only to the partnership firm and individuals. So sole proprietorship were covered under the individual, whereas the partnership firm, it was applicable to the partnership firm by the virtue of section 2. Whereas leading to that amendment, 3 categories have been classified. So the classification was among personal guarantee to the corporate debtor, that was section 2 clause E, partnership firm and the proprietorship firm, that is section 2 clause F, and the last one is individual other than what is specified above. So individual other than personal guarantor, individual other than sole proprietorship and the partnership firm. So that was one of the ground of challenge which was made before the Supreme Court, that how such classification can be made possible, or how the central government can amend or bring into force part of the code in this manner. So this classification was challenged, and that was decided by the Supreme Court in Lalit Kumar Jain judgment. In exercise of the power conferred under section 1 subsection 3, which is the power of the government to amend the law or to bring any law into force. So in exercise of the power conferred in subsection 3 of section 1 of the code, wide notification dated 15th November 19, issued by the Ministry of Corporate Affairs, part 3 of the code relating to insolvency and bankruptcy of individual and partnership firm, insofar as applicable to the personal guarantee to the corporate debtor, including the impugned provisions, were notified. So the notified, till date, the notified part is only extended to the personal guarantor and not to an individual or the partnership firm. The validity of the said notification was challenged before the Honorable Supreme Court in the case of Lalit Kumar Jain versus Union of India and others, on the grounds inter alia, the central government, while issuing the notification, has acted in excess of the power conferred upon it. It was contended that the power conferred upon the central government under section 1 subsection 3 could not have been resorted to in a manner so as to only extend the provision of part 3 of the code selectively in relation to the personal guarantor, because basically the initial amendment was made to section 2. By amending section 2, they have brought within the ambit, first they have brought within the ambit of this code its applicability, which was extended to personal guarantee. So guarantors, the personal guarantors have been included. And after inclusion of this personal guarantor under section 2, part 3 was notified, made effective, but only for a specific nature of the stakeholder, and that is a personal guarantor, but not extended to an individual or a partnership firm. So this was challenged before the Supreme Court. The apex court in the case of Lalit Kumar upheld the whereas of the said notification. So Supreme Court has upheld the validity, the constitutional validity of that notification dated 15th November 19, and held that the liability of the personal guarantor is not discharged merely on the discharge of the liability of the principal debtor. So that is something which is going to be a moot court of discussion, that whether the liability of the personal guarantor, because section 128 of the Indian Contract Act is not being applied in a manner in which section 128 is drafted. As far as 128 is concerned, it is very clear that my liability will run with the liability of the principal borrower. So as far as 128 is concerned, that 128 was one of the moot point of discussion before the Supreme Court when this challenge was made. So issues in Lalit Kumar Jain was, first is with regards to the validity of the notification dated 15th November, that validity was challenged. And the second one was, does sanctioning of the corporate debtor resolution plan relieve the corporate debtor's personal guarantor? So these were the 2 points on the basis of which the Supreme Court has decided in this judgment. So let us see this. As far as the treatment of personal guarantor under the IBC, it seems to have been finally put to rest by the Supreme Court by the way of this judgment of Lalit Kumar Jain. The inception of this tale, what the notification dated 15 November, brought into force part 3 of the code, but mark it only for the personal guarantor to the corporate debtor, which dealt with the insolvency of individual only so far as it relate to the personal guarantor to the corporate debtor. It has targeted the promoter of the Indian entities undergoing insolvencies. And that's why when you see that Dilip Kumar judgment, it was led by multiple writ petition, which includes the Anil Ambani's personal guarantee. And that was also decided by the Supreme Court recently on 9th of November. The major ground, the notification led to a string of challenges as to the constitutionality before various high courts. On October 29, 2020, the Supreme Court has stayed the High Court from admitting or hearing any or all the writ petition, challenging the impugned notification and transfer to itself all the matter pending before the various High Court. So writ petitions have been made by several personal guarantor in this connection. But on October 29, 2020, it was the Supreme Court who said that High Court should refrain from passing any order or should refrain from accepting any application. And all the applications which were pending before the Honorable High Courts have been transferred and decided by the Supreme Court in Lalit Kumar judgment. The major ground of challenge against the impugned notification was that the central government did not have the power to bring into force selected part of the code. It's not only the selected part of the code, but also the selected part of the code for the selected category of the debtor that was challenged. And in turn, the subcategory of the individual being the personal guarantor. The contention was premised on the claim that power under section 1 subsection 3 of the code to bring the provision into force was only a function of conditional legislation, whereas the action undertaken through the impugned notification was inherently legislative in nature. The court analyzed a number of precedents to determine the scope of delegated legislation and finally held that the power granted to the executive wing was limited to determine when a particular provision must be brought into force and allowed making of peripheral modifications to effectively administer such law. So basically, the power of central government was very much legitimately exercised. That is what decided by the Supreme Court. The provisions of the code were brought into force in a phased manner from the very inception of the implementation, which empower government to decide when a particular provision would be made effective. At the beginning, it was important to set up a fundamental pillar such as regulatory body, that is IBBI, related provisional professional agency like IPAs or IUs, again IPs. Thereafter, the provisions pertaining to operationalizing the code with respect to entities such as companies or the LLPs were brought into force. So this is well within the power of the government to decide when a particular provisions of the law is required to be enacted. The phased implementation of the code was deliberated before by the Supreme Court and designed to fulfill the objective or the underlying objective of the code, having regard to its priorities. So basically, Supreme Court has settled this particular challenge which was made in this Lalit Kumar judgment. Further, Section 2 of the code lays down the list of entities that code extends to, and erstwhile unamended Section 2 of the code did not, this is what I said, that unamended Section 2 has never differentiated between the category of individuals, but amendment has categorized the individual into subcategories, including personal guarantor to the corporate debtor. The personal guarantor to the corporate debtor, partners of the firm, and individual were all grouped together under the erstwhile unamended Section 2E. However, the erstwhile Section 60, so resulting impact is there on Section 60 of the code. I'm just sharing 60 for the sake of discussion. Section 60, so impact of the Section 2 Clause E has also been extended to Section 60 of the code, which deals with the jurisdiction. I'm just sharing Section 60 on screen. So this resulting impact of that amendment in Section 2 has also impacted section 60. I'm just sharing section 60 on screen. So this is section 60. So this is quite important to again understand that because part 3 of the code was notified for the personal guarantor, it was also very important to notify the jurisdiction. And the jurisdiction was decided and not the DRT, but the NCLT. Section 60. Now, as far as section 60 is concerned, this is what we can see here. It is out of the amendment, and that is 2018 amendment dated 6th of June 2018. The adjudicating authority, this is section 60 of the Insolvency and Bankruptcy Code. The adjudicating authority in relation to insolvency resolution and liquidation for corporate person, including corporate debtor and personal guarantor thereof, shall be NCLT, having territorial jurisdiction over the place where the registered office of the CD is concerned. Now, subsection 2, without prejudice to subsection 1 and notwithstanding anything to the contrary contained in this act. That is code. Where the corporate insolvency resolution process or a liquidation proceeding of the CD is pending before the NCLT, an application relating to insolvency resolution or a liquidation or a bankruptcy of the corporate guarantor. So if it is a corporate guarantor, then CIRP and liquidation. But if it is a personal guarantor, then bankruptcy shall be filed before such NCLT. Which NCLT? The NCLT where the CIRP or the liquidation of the principal borrower, that is a corporate debtor, is pending or ongoing. I'm repeating for the sake of requirement again. Without prejudice to subsection 1 and notwithstanding anything to the contrary contained in this code. So even though the jurisdiction other than this provision which says that as far as the individual and partnership firm is concerned, it is going to be decided by the DRT and appellate authority is going to be DRAT. But this is what provided that notwithstanding anything to the contrary contained in this code where the corporate insolvency resolution process or a liquidation proceeding of a corporate debtor is pending before the bench of NCLT, then application relating to insolvency resolution or a liquidation or a bankruptcy of the corporate guarantor or a personal guarantor, as the case may be, shall be filed before such NCLT. So that was a resulting impact of amendment in section 2. As insolvency resolution process or a liquidation or a bankruptcy proceeding of a corporate or a personal guarantor of corporate debtor pending in any court or a tribunal shall stand transferred to the adjudicating authority dealing with the insolvency resolution process or liquidation proceeding of the corporate debtor. So this is something which was amended. I'm again going back to our primary discussion with regards to operationalization of part 3. So yes, this is what we had a discussion up till now. So that 2018 amendment, which has amended section 2 of the code in a manner as if the applicability of the code shall extend to one more category or one more species of this particular IBC, one of the stakeholder has been introduced as a personal guarantor. And because of that introduction, the jurisdiction with regards to an application against the personal guarantor was also decided by the clarity which was provided through the provision of section 60. So as far as this 2018 amendment is concerned, 2018 amendment has modified section 2 clause E, subcategorized individually into 3 parts, that is personal guarantor of a corporate debtor, partnership firm, and individuals who are again may be considered as a proprietor or other than a proprietor. This was calculated move following the recommendation of the report of the working group of insolvency committee, emphasizing the intrinsic relationship. Now, this was the rationale provided by the Supreme Court that why it was amended or why part 3 was made operationalized only for this category of the stakeholder known as a personal guarantor. So the rationale was provided by the Supreme Court and stated that emphasizing the intrinsic relationship between the personal guarantor and the corporate debtor, and how the insolvency resolution process of the corporate debtor would be in any way incomplete without bringing the personal guarantor under the scope of the same. And that was the urgency for which part 3 was notified. 2018 amendment also altered section 60 in the IBC relating to the liquidation and bankruptcy in respect of this category. So not only the provisions were notified with regards to insolvency resolution of the personal guarantor, but also the bankruptcy, that is the next chapter, that is chapter 4, and subsequent chapter of part 3 was also notified, which deals with the bankruptcy of the personal guarantor. Therefore, the court held that 2018 amendment, as far as it inserted clause E of section 2 and altered section 60 subsection 2, sought to streamline the resolution process. It sought to bring together all stakeholders under the same forum and aid the creditor to consider the holistic approach to the nature of the asset available, either during the corporate debtor insolvency or even later, and to facilitate creditor in framing a realistic plan, keeping in mind the prospect of realizing some part of creditor due from personal guarantor. And so this was the rationale which was given in Lalit Kumar judgment. Court therefore held that the impugned notification is not in any case unconstitutional, and that amounts to impermissible and selective application of the. So it took into account the phased implementation of the code since its inception, and that the intent of the legislature was never that the code should be made applicable to all the individuals, including personal guarantor. Conversely, there is a sufficient indication in the code by section 2 clause E 5 subsection 22, which deals with the definition of the personal guarantor, section 60 and 179 indicating that the personal guarantor, through forming a part of the larger group of individuals, were to be in view of their intrinsic connection with the corporate debtor, dealt with differently through the same adjudicating process. So basically, that was the Supreme Court, you can say, a base on which the Supreme Court decision was passed. Now, this is something which is very critical issue. That is second issue. As far as the personal guarantee, if I'm the personal guarantor given a guarantee on behalf of a corporate debtor, and suppose if the resolution plan for a corporate debtor is approved by the COC, whether I will be free from that guarantee or not. So here one more moot court or one more a moot question which was emerged before the Supreme Court in Lalit Kumar judgment. And that again goes in favor of the creditor and against the personal guarantor. The secondary issue addressed in the judgment was the juxtaposition of the treatment of the personal guarantor under the code, the right of the guarantor under the Indian Contract Act. The successful end of the resolution process of the CD is synonymous with successful resolution plan, extinguishing the whole or part of the debt. Although the claim against the corporate debtor stand extinguished, the same treatment is not rendered to the personal guarantor, as all avenues for the creditors are open to proceed against the personal guarantor. And this is what I said, that now there will be a shift, or there is a possible shift in the manner in which the resolution plans will be drafted. It may be a possibility that dissenting secured financial creditor may oppose it by preferring an appeal, and may be possible that they who approved the resolution plan and those who have not approved the resolution plan will ended up their dispute by again referring the matter to the NCLAT. And for, because see, there is a difference between me who is extending a personal guarantee and me who is extending a personal guarantee and also creating security over my personal asset. So the time will tell that how the resolution plan will further protect the interest of the personal guarantor. And if it is affirmed or approved by the committee of creditor, then there is no question of challenge considering the very latest judgment of the NCLT in this regards. We will be dealing into the same. But as far as this secondary issue is concerned, the secondary issue which was addressed in the judgment was that treatment of the personal guarantor under the code against the right of the guarantor under the Indian Contract Act. Because, see, if I'm the guarantor, if I'm a guarantor who has given a guarantee on behalf of a corporate debtor, also I do have certain right against the corporate debtor. A right as if I can exercise my right equally as a creditor of the company. So that was one of the point which was decided by the Supreme Court through this Lalit Kumar Jain judgment. The successful end of the resolution process of the CD is synonymous with successful resolution plan, extinguishing the whole or part of the debt. Although the claim against the corporate debtor stands extinguished, the same treatment is not rendered to the personal guarantor, as all avenues are open for a creditor to proceed against the personal guarantor. Now, 133 of the Indian Contract Act.
Can I ask you something?
Please, sir. Please, sir.
Sir, Section 128 of the Indian Contract Act, which is made much before the independence by the British,
Absolutely,
has made the liability of the guarantor very clear, coextends with the borrower, and so many litigations went through it. There is no doubt about it. I think IBC is complicating by the judgments. See, you just now said a person giving a personal guarantee to the corporate and also he's charging his assets. What's the difference, sir? I am trying to secure the debt. I am standing as a guarantee. I think we are interpreting and making it legally complicated in a sense that the effect of the IBC we are prolonging. That's what I feel it. Because for me, the guarantor's liability is a well-settled law, thanks to Section 128 of the Indian Contract Act, much before, many centuries before this.
But here the say of Supreme Court is, though resolution plan settled the dust, but it is a involuntary act. This is something which is going against my wish, against my will. It's because of the operation of law. A resolution plan was proposed, accepted by the committee of creditor, a supreme committee of creditor, but that only akin to the liability of the corporate debtor. Liability of the corporate debtor or the asset of the corporate debtor. And this is not something which is amicably or which is going to be a voluntary act on the part of the corporate debtor with its creditor. It's just because of, by the benefit of the operation of law, the liability of the corporate debtor stand discharged. This is what provided in 133. We are going to check first of all, but I agree to your point that supremacy of 128 is something which is right now hampered because of this various judgment. Otherwise, now this is the practical problem which is happening. The corporate debtor, I'm talking about the corporate debtor, the MSME promoters who are proposing the plan, getting their plan approved by the COC and from the subsequently from adjudicating authority also. But what happens? The moment their plan gets approved and the stage comes with regards to implementation of the plan, that secured creditor is initiating Section 95 application against them. So I, who put all my brain into that resolution plan to make it implemented, tomorrow I will be in the same position. I will be back to the same position wherein the company was since long. So tomorrow I have to defend my own case before the same adjudicating authority against the same creditor who recently approved my own resolution plan. So basically the act of the secured creditor by going against me and by going against the corporate debtor at the same time is double pinching. I agree to your point, but somehow the Supreme Court is not deciding is not filling in the same manner as if the personal guarantors are filling. So we will see that what exactly the rationale of the Supreme Court in this connection. So 133 of the Contract Act lays down that the surety would stand discharged. So this is very relevant, sir. 133 of the Contract Act lays down that surety would stand discharged of the liability under a contract of guarantee if the term of contract are varied without the acquiescence of the said surety. Now, this is very important as far as 133 of the Indian Contract Act is concerned. I'm reading it again. 133 of the Indian Contract Act lays down that surety, as far as the surety is concerned, or a guarantor, would stand discharged of the liability under the contract of guarantee if the terms of contracts are varied without the acquiescence of the said surety. The court, however, relied upon the pronouncement in SBI versus Sri Ramakrishnan, wherein it is observed that the language of section 31 of the code clearly made the approved plan binding on guarantor. So this is what I said. Now that depends upon how the resolution plans are being framed, and the framed resolution plans, whether these are
Section
acceptable.
31 makes it binding on the guarantor. That's very clear. Okay.
That's binding on the guarantor.
So he cannot dispute it. That law is settled, right?
Absolutely.
So, but still, as the right of the creditor to enforce further, if the entire debt is not discharged, that still remains.
Sir, that is what my point is. When we will be dealing with the recent NCLAT judgment in Ujas Energy, we can able to understand that by preparing or by drafting the resolution plan in a manner in which the personal guarantor's liability is getting extinguished, if it is supported or consented by the COC and subsequently by the adjudicating authority, probably the personal guarantor can take the benefit of that approved plan. So that is very recent judgment of the NCLAT, and which clearly gives an impression that if the resolution plan permits such guarantee to get over or permits such liability of personal guarantor to get extinguished, and if it is accepted by the committee of creditors and subsequently by the adjudicating authority, then one secured creditor cannot go against the personal guarantor after approval of such plan. We will be dealing into that part, sir. But as far as section 133 is concerned, which talks about, that is of the Indian Contract Act, lays down that surety stand discharge of the liability under the contract of guarantee if the terms of contracts are varied without the acquiescence of the said surety. The court, however, relied on the pronouncement of SBI versus Sri Ramakrishnan, where it is observed that the language of section 31. But again, I have not come across any dispute wherein approval of the resolution plan is being challenged by the personal guarantor. Because see, going by the provision of section 133, this application can be made by the personal guarantor before the adjudicating authority, challenging the content of the resolution plan if the resolution plan is not having a clause giving immunity or liberty or making a personal guarantor fee free from all the liability post approval of the plan. So 133 I feel is very relevant if it can be used at the appropriate time. 133 of the Indian Contract Act lays down that surety would stand discharged of the liability under the contract of guarantee if the terms of contracts are varied without the acquiescence of the said surety. Because it happens, terms of contracts are being varied without the acquiescence of the said surety, but again section 31 makes it binding. Section 31 makes it binding on all the stakeholders.
Sir, preparation of a resolution plan in no way amounts to variation of a contract.
See, that is not leading to variation of contract, but contrary, it is my secured creditor which is accepting what is being proposed in the resolution plan. So not directly, but indirectly, there is a variation in the contract which I was having with my secured creditor if he is accepting any of the proposal of the resolution plan.
when we are saying that IBC is supreme over other acts, why we are bringing controversies like this?
Then in that case, and that is the only reason this 128 is losing its basic rationale. It's just because of the preference of the IBC over the other law. But anyways, the court, however, relied upon its pronouncement in SBI versus Ramakrishnan, where it is observed that the language of Section 31 of the code clearly made the approved plan binding on the guarantor. The court rightly held that the approval of the plan would not ipso facto discharge a guarantor of their liability under the contract of guarantee, as extinguishment of debt of the corporate debtor under the code was a result of involuntary process, that is by the operation of law or due to liquidation or insolvency proceeding, the same could not absolve the surety of their liability which arise out of the independent contract. So this is what provided reasons which are provided that why section 128 is not applicable. Let us have it for one more time, because this is quite relevant, which is there in the matter of SBI versus Ramakrishnan. 133 of the Indian Contract Act lays down that surety would stand discharge of the liability under the contract of guarantee if the terms of contracts are varied without the acquiescence of the said surety. This is 133. Now, as far as the resolution plan is concerned, the approval of the resolution plan is binding on all the stakeholders. The court rightly held that the approval of the plan would not ipso facto discharge the personal guarantor of the liability under the. So now the question is, if the resolution plan per se provide, that the guarantor, the liability of the guarantor will be extinguished or the guarantor will be discharged, and if that plan gets approved by the COC, then tomorrow the interest of the personal guarantor shall remain protected. So this clearly indicates.
That is true. Okay.
Absolutely. So court rightly held that the approval of the plan would not ipso facto discharge the personal guarantor of their liability under the contract of guarantee, as extinguishment of the debt of the corporate debtor under the code was a result of involuntary process. So basically 128 talks about a voluntary process, whereas approval of the resolution plan by the way of operation of law, that is CIRP or failure of CIRP, that is a liquidation, that is not a voluntary process, and that's why it shall not absolve the surety of their liability which arise out of the independent contract. So leading to this, 128 is losing its charm. Sir, what is your say in this?
No, sir, I agree that actually because IBC has supremacy over the act. But if you say that actually the guarantor's liability is to be excluded, if the COC agrees it, I agree with that. But if not, then his liability remains.
No, but what is your say with regards to this statement? The extinguishment of debt of the corporate debtor under the code was a result of involuntary process, and that is the reason which is cited that why 128 will not have its supremacy.
Say involuntary, I don't think it is how far it is correct, because it is the right of the creditor to go for a litigation, and he has many options, but he choose IBC. When we say involuntary process,
absolutely.
So the law is operated by the wish of the creditor.
It was, yes. So it was the instance of the creditor, such application. It was at the instance of the creditor, such application was made and admitted. Anyway, sir, finally, the Supreme Court has ruled that the impugned notification is legal and not ultra vires. So basically, the notification dated 15th November, constitutional validity which was challenged, it was settled by the Lalit Kumar Jain judgment. So legal provisions which were dealt in Lalit Kumar Jain and Union of India and other, let us have it for one more time, which were the legal point. The one is with regards to the power of central government to make the code effective in a phased manner. And the second one with regards to the liability of the personal guarantor. So these were the two basic legal provisions on the basis of which the matter was referred before the Supreme Court. One is, this is what we have seen.
Sir, first one is administrative. We have no view on the matter. But second one,
correct.
Lalit Kumar judgment in that liability. What is the final view according to you?
According to me, sir, final view clearly states that if I'm the personal guarantor, extended a guarantee on behalf of corporate debtor in favor of a creditor. Now, suppose if the resolution plan is being approved, if it is consented by the creditor. So again, here I would like to go with the purpose of the code. Here I would like to go with the purpose of the code or objective of the code. And this is what time and again we have seen that tribunal are passing an order mentioning the fact that this is not a recovery forum, or this is not a recovery mechanism, or the intent is not the recovery. Now here, if you are admitting that the liability of the personal guarantor will not comes to an end even after the approval of the plan, you are calling the further litigation for recovery.
Okay.
Intent is resolution. Intent is resolution. It's a resolution, and I must say, no corporate debtor gets revived or resolved without having, especially I'm talking about the MSME promoters. Because there are several liberties which are given to them under section 240. Read with section 29A. So on the one side,